As I battled Finley the Idiot's attempt of fraud, I was also pursuing evidence that incriminates Maria Viggers as part of my investigation in the lawsuit. In early September of 2015, the University of Michigan produced records in response to the subpoena, which I had submitted almost a month earlier. The entirety of those records were documents of which I was already aware. In fact, I already have most of those documents because those were the outcome of the 2 FOIA requests that I submitted to the university in the previous months while I was still employed. This meant that the University of Michigan was inconclusive and I was still unaware of what was the allegedly additional information that prompted the university to withdraw its offer of employment. The only differences are that now the documents were no longer redacted as they were in the FOIA processes, and that the university produced the report of April 28 about the telephone call where Maria Viggers said that the university will be sorry if it hired me and that bad things will happen to the university. The university made me wait almost a month to provide me with documents that the university already had identified even before receiving the subpoena. Just like it took 3 weeks to comply with my FOIA request, this is another example of how the University of Michigan delays legal matters for no reason. In reaction to the university's inconclusive response, I inquired with Carter-Ranno, the Human Resources Administrator of the university, as to what was the additional information given that the university's production shed no light on this matter. Carter-Ranno never responded to my email. A few days later, another university employee from Human Resources, whose name is John Lund, responded to my inquiries to him, and he categorically stated that the university had fully responded to the subpoena and that there were no more records in regard to that subpoena. That was a contradiction on the university's part because on the one hand, the university referred to additional information when it withdrew its offer of employment, but on the other hand, the university was giving no information that would explain what was the real cause for withdrawal of the offer of employment. That was the state of affairs when it was time to attend the hearing on October 21st. Initially, October 21st was the date for which Finley the Idiot scheduled his motion for a more definite statement, the dilatory motion which I mentioned in the previous segment. But now that I have denounced Finley the Idiot, denounced and proved Finley the Idiot's attempt of fraud and that he cancelled his motion, I was able to preserve that date for my motion for summary judgment. At that type of motion or hearing, summary judgment, there is a possibility that the entire case might be decided without having to go through the subsequent stages of normal court proceedings. That scenario should happen when evidence makes it clear that one of the parties, the one which didn't file the motion, simply has no chances of prevailing in any portion of the lawsuit. That seemed to be the case here because all the evidence that the University of Michigan produced pointed to Maria Viggers as the only person liable for the damages I was enduring. October 21st was also the first time I met Finley the Idiot in person. Usually when you meet somebody new, you exercise courtesy and you are open and polite, but that is hard to do when you are dealing with a difficult situation and you know that that new person is a crook helping precisely the individual who has been targeting you for months. Additionally, because of the incidents from Finley the Idiot's attempt of fraud, his purported illiteracy, and his inappropriate allegations in court documents, I must admit that beforehand I just didn't have a good concept of Finley the Idiot. Additionally, when I saw him physically, his persona didn't seem to me to radiate any self-respect. So meeting Finley the Idiot was pretty much like meeting some nobody. In court, I made the point that Maria Vigers tried very hard to sabotage my career, and that now it was ironic that Maria Vigers all of a sudden wanted to know how is it that I lost my employment and the employment prospect. The judge denied my motion, meaning that I had to continue with my investigation and discovery process, because the University of Michigan stated very clearly that it fully responded to the subpoena, that there were no more records, and that it was not going to release any more information. My next option was to inquire with Al Pacha, which is what I did in the night of October 21st. That was the first time I contacted Al Pacha since the day he terminated me. In that email, I asked him for a copy of my employment file, and I asked him to include any feedback notices and requests from the University of Michigan. By underlining that item, I indicated that I had a special interest in that matter. I was just trying to find out what was the mysterious additional information that prompted the university to withdraw its offer of employment. On November 2nd, Al Pacha responded to my request with a letter and a set of documents, most of which I already had or was already aware. But there was no indicator of what was the additional information. Al Pacha's letter made me suspect that maybe he was concealing from me some relevant information, in particular because he totally ignored the only item I had underlined in my request. Instead, he focused with the statement of that there are no performance reviews. That's why I replied to him to ask him on the specific matter of feedback notices and requests, although he never followed up with that inquiry. At about the same time, I started receiving the results of a separate discovery venue I was pursuing. I submitted subpoenas to 2 telephone companies, which were the telephone service providers to Maria Vigers. These 2 companies are Vonage and Verizon. At the outset, I should point out that that line of investigation cannot be exhaustive because it is impossible to tell how many telephone numbers an individual is using, especially if there is no contact with that individual. In the case of Maria Vigers, she is known for using multiple telephone numbers. I was interested to know whether any phone calls were proceeding from the numbers of Maria Vigers to the numbers of the landlord who reported that a supposed agent of the FBI gave the false information about my father as to being investigated for rape when my father was filing his application with that landlord during his divorce proceedings in 2014. I was also interested to know whether Maria Vigers made any other phone calls to either the University of Michigan or Al Pacha, as that would be in violation of the personal protection order against her, depending on the dates on when she made those calls. It will also unveil an ethical violation by the university, because when I notified the university about the personal protection order against Maria Vigers, I also asked the university to notify me if Maria Vigers approached the university again. When the FBI issue was brought up in my father's divorce proceedings, the attorney representing Maria Vigers denied that she made those phone calls to my father's landlord. Instead, the attorney focused on theories or stories as to how my father is careless with his documents and leaves his papers all over the place. It appears as if the attorney or Maria Vigers were trying to explain how Maria Vigers could have learned about my father's prospect of moving out and renting with that new landlord. But that argument is entirely irrelevant. The key issue here is whether or not Maria Vigers impersonated an agent of the FBI to calumniate my father and to sabotage his prospects of moving out. The records that Vonage produced in response to my subpoena show a number of phone calls from Maria Vigers' telephone numbers to the telephone numbers of that landlord and its parent company. The dates of those phone calls match very closely the dates which the landlord's employee reported to the police. In the file of my father's divorce proceedings, Regarding the FBI issue, there is nothing that could overcome or outweigh the evidence I obtained on my own a year later. A telephone record showing the date, time, duration, source number, and targeted number of phone calls is far more convincing than the bare denials that Maria Vigers made in court through her attorney. This is why I don't understand why my father's lawyer apparently never pursued the subpoenas to Maria Vigers' telephone numbers. Months later, my father desisted from his divorce proceedings because the parties reconciled. But 2 years later, in a separate court case, my father complained bitterly that he had to pay around $60,000 in attorney fees during his divorce proceedings, or as a result of his divorce proceedings, which means that each attorney involved in that case earned around $30,000. By contrast, I remember that the subpoena I submitted to Vonage had a cost of $150 plus $10 for serving it by fax. Because I subpoenaed both Vonage and Verizon, that had a total cost of $320. With that much lesser cost, I was able to obtain evidence which is much more conclusive than what is found in my father's filed proceedings. This is another example of how representing yourself in court may turn out to be much more effective than paying an expensive attorney. Another new and interesting aspect about the subpoena records produced by Vonage is that on April 10th of 2015, Maria Vigers called the police department of the University of Michigan. This is relevant because the university didn't notify me about that phone call, and the university omitted any records related to that call in its response to my subpoena. The information released by Vonage is evidence that the University of Michigan was concealing from me records that are within the scope of the subpoena, and consequently it is evidence that the university failed its obligation to fully comply with my subpoena. Of course, this also means that the university's statement from a few days earlier, in the sense that it fully complied with the subpoena and that there were no more records in response to the subpoena, was false or outright fraudulent. In response, or as a result to this new finding from the Vonage information, I submitted a second subpoena to the university with the sole purpose of obtaining a recording of the phone call that Maria Vigers made on April 10th. Now, by specifying the date, time, and duration of that phone call, the university will have no other option but to produce that recording. My court filings as of early November of 2015 reflect pretty much all I had regarding the university's records. In fact, I didn't even have access to some of the documents that I have displayed in this segment or in the first two segments of this video, and Al Pacha never followed up with my clarification pertaining to the item of feedback notices and requests by the University of Michigan. In this situation of stalemate, I began pursuing discovery on my father's former employer, given the information that Maria Vigers also interfered with his employment in 2013. There are some analogies between my father's work situation and mine, because just like what happened to me, my father worked for 7 years for a company, and a few months after Maria Vigers started interfering with his work environment, he was terminated. The rationale behind my initiative to conduct discovery on my father's former employer is to figure out in more detail the detrimental effects of Maria Vigers' interference with people's work environment. It was also aimed at demonstrating how an employer in general is reluctant to openly admit or acknowledge that it terminates one of its employees as a result of the interference and harassment by Maria Vigers. On November 17th, the university gave me the recording of the phone call that Maria Vigers made on April 10th, and surprisingly, the university also released a high number of records which should have been produced back in September. before the university made the fraudulent statement that there were no more records in response to my subpoena. As an example, in this email on April 28, the Human Resources Administrator, Lady Rastige, made reference to precisely that phone call by Maria Vigers to the university's police department, also known as CSSB. This shows that Human Resources of the university was aware of that phone call, and yet the University of Michigan concealed from me that record despite being within the scope of my subpoena. By the way, here and in the first segment, when I talked about the stupid suspicion as to whether I altered the personal protection order against Maria Vigers, I pronounced this employee's last name as Rastige, although I am not sure whether that is the correct pronunciation or whether it should be Rastig or Rastig or Ra. But that's what happens when you don't have access to the semi-gods of the University of Michigan, and you simply have no occasion to learn or to listen to how to pronounce the last name of some of the members of upper-level management. And at this point, I am not going to inquire with the university on how to pronounce the last name of one of its markedly incompetent employees who conspired against me. In the release on November 17th, the university included several repetitions of some documents as well as many blank pages. That is how the university could eventually argue that it gave me over 300 documents, when in reality it was 300 pages, many of which were useless because they either had no content whatsoever or they were repetitions. Imagine that you open a book and find out that many of its pages are scratch paper, or that some pages are repeated multiple times. That is how the University of Michigan approaches its obligation to fully comply with subpoenas. However, one important record in that release originated from Al Pacha, who on July 21st sent an email to the university to falsely accuse me of sending direct threats to him. He also requested to meet with the university as soon as possible, and as background for his false accusations, he made the false statement that it will be illegal for him to resume my green card sponsorship for as long as I retained my university's prospective employment. During the meeting between Al Pacha and the university, Al Pacha elaborated on his fraudulent accusations. As you can see in this email by one of the employees of the university, an immediate effect of that meeting was that the university began its deliberations on how to sever its relations with me and to withdraw its offer of employment. That explains why Al Pacha always ignored my item of feedback notices and requests by the University of Michigan when I requested him for a copy of my employee file. This is because Al Pacha himself prompted the university to take adverse actions against me. Later on, I will address the falsehoods of Al Pacha's fraudulent statements because they are a topic in and of themselves. For now, I want to make two remarks. First is that there is a very strange coincidence in the timing of the events because on July 21st, the police served upon Maria Vigers the personal protection order against her at 9:45 in the morning. And within 6 hours, Al Pacha was making false accusations against me, something unprecedented during the 7.5 years I worked for him. That suggests that these two events might be connected, especially if we consider the history of Maria Vigers' unlawful actions in response to adverse events that happened to her. The second remark is that the delivery or the release on November 17th is not the result of the university's managers looking themselves in the mirror and saying, okay, it's time for us to do the right thing about this subpoena. No, nothing like that. What happened was that the University of Michigan and lawyer Finley made arrangements to take the position of its associate director, Lukeland Gentles. The position was scheduled for 3 weeks later, and the University of Michigan obviously could foresee that Mr. Gentles would have a very hard time during his deposition unless the university released more records. That shows that the university does not comply with the law for the sake of honesty or for the sake of complying with the law. The university complies with the law only if it is convenient to the university itself. The information released by Bonas also shows that Maria Viggers was approaching multiple law enforcement agencies at the same time that she was falsely accusing me with the FBI. In fact, many of the emails that Maria Viggers sent to the university's director, Richard Robin, are forwards of her false accusations with the FBI, as if that constituted any proof of her defamatory statements about me. Also at that time, I was obtaining the information or the evidence regarding the incidents between my father and Maria Viggers back in year 2014, and therefore it was time for me to conduct discovery on my father, because as I expressed in the pleadings in my complaint, I was not certain as to whether my father was an accomplice or whether he was knowledgeable and negligent regarding Maria Viggers' actions against me. Relevant to my investigation regarding the possible identity theft by Maria Viggers is the police report that ensued in year 2014, when my father's landlord reported the supposed agent of the FBI who calumniated my father. That incident prompted the police to interview my father. During that interview, my father made false statements about me. For example, he falsely portrayed me as a hacker, and he mentioned that he has had several issues with my mom and with me. That is quite strange because as of the time he spoke with the police officer, we hadn't had any contact with him for years. In particular, my parents stopped talking to each other in year 2000 or 2001, whereas my relation with him ended in 2007, and except for the one occasion when we ran into each other in year 2011, and when we failed to reestablish our relation at that time, there was no other communication between my father and I. So it was weird that he would give such an outdated information to a police officer who was investigating a current issue. For that reason, I was interested to know what issues my father thinks he has been having with me. Because lying to a police officer is a serious matter, I wanted to believe that my father will not be dumb enough to make false declarations. But then I read the next police report about another incident, and that made me seriously doubt my father's judgment. The incident leading to the other police report is Maria Viggers' false accusation of domestic violence. Even though my father obtained restraining orders against Maria Viggers, which is one reason why my father was incurring such expensive attorney fees, Maria Viggers continued meddling and interfering with my father's environment. On one occasion, Maria Viggers was cooking chiles and tortillas, which according to the police report, it's my father's favorite meal. Because remember, when you are falsely accused of domestic violence, it is so important that you let the police know that certain dish is your favorite meal. But anyway, the communications reflect that initially my father didn't want to see Maria Viggers, and after being threatened, blackmailed, harassed, or maybe after dining a very distasteful pizza, my father agreed to see Maria Viggers, who in the following day came over with a Pyrex, tortillas, and what my father calls the famous chiles. They went to Walmart, they did other things, and like any couple of high school sweeties, they began talking about their divorce proceedings. Apparently they had an argument, and Maria Viggers ended up going to the police station to make the false statement that my father hit her knee with his knuckles. Later on, the police officer asked my father on whether he had ever punched Maria Viggers. That's what prompted the police report, which in its field or section for weapons lists hands, feet, teeth, etc. That's too bad because I was planning that once I resumed my relation with my father, I will make him some gift, such as these goofy teeth, or these finger tentacles, But now that they have reconciled, I just don't want to introduce weapons in the madhouse currently located in Chelsea, Michigan. Man, it's too bad because I no longer keep the receipt of what I pay for these items in Walmart. The point I want to make here is that obviously my father is controlled by Maria Vickers even when they are fighting each other in court. I still want to find out whether there has been any identity theft affecting me or my mom's identity. Also, at some point in the lawsuit, Finley the Idiot began litigating on the basis that because Maria Vickers was mentally ill at the time she made the defamatory statements, that therefore she could not be held liable for any damages. Even assuming that that argument is legally valid, which it's not, that argument entitles me to ascertain who of my father or Maria Vickers initiated or perpetuated the false notion of me being a hacker. Was it Chile's witch or Chile's dumb? Each scenario has its own legal ramifications in this lawsuit, especially since many of the false accusations that Maria Vickers made when she approached the FBI and while she was harassing the University of Michigan are in the sense of me hacking her computers, her electronics, and her everything. And as we saw in the report from year 2014, my father was spreading the false portrayal of me being a hacker. For that reason, I intended to conduct a discovery on my father by taking his deposition and by subpoena him for documents. But then Finley, who was also representing my father in this lawsuit, filed a motion to prevent me from conducting any discovery on my father on the argument that he was protected by spousal privilege. This lawyer cited the Michigan statute that formulates the spousal privilege, MCL 600.2162, which states that a husband shall not be examined as a witness for or against his wife. Courts have explained that the reason of being of spousal privilege is to protect the marital harmony. The courts presume that if a husband is compelled to testify for or against his wife, or vice versa, the most likely outcome is an impairment to the marital relation. However, the same Michigan statute also provides a number of exceptions, one of them being when the cause of action or lawsuit grows out of a personal wrong or injury done by one spouse to the other. That exception makes sense because if one spouse is doing an injury or personal wrong to the other, that is indicative that there is not so much marital harmony and therefore their privilege has nothing to protect. Here is how Judge Carol Conkey partakes in the obstruction of justice in this topic. When Carol Conkey was campaigning for the judicial office she currently abuses, she made the statement, "Any judge can follow the law. That's not the hard part of being a judge." Then the question becomes, why did Judge Conkey refuse to recognize that the exception to spousal privilege applies in my lawsuit? In some of the emails where Maria Vickers was sabotaging my employment, she also made defamatory statements about my father. That is, Maria Vickers not only was calumniating me, but she was also calumniating my father, her spouse. Because defamation is a personal wrong, that triggers the exception to the spousal privilege as contemplated in the Michigan statute. Moreover, the Michigan statute only prohibits the testimony for or against the defendant wife, and of course it also protects the marital communications. But it does not prohibit any and all testimony or any and all discovery on the witness spouse. In fact, a case or an opinion released by the Michigan Supreme Court states that notwithstanding the existence of a privilege, the witness is still subject to discovery on matters that go beyond the scope of the privilege at issue. The subpoena which I submitted to my father certainly goes beyond the taking of his deposition and it goes beyond the marital communications. It also requested items that have to do with the possible occurrence of identity theft and also as to whether he took any steps to prevent the harmful effect of Maria Vigor's unlawful actions against me. Now that my father, through his lawyer Finley, was arguing that I was stalking and harassing him, that gave even more reasons to conduct a discovery on him, precisely with regard to the identity theft. And that identity theft might give further clues as to what else happened with the University of Michigan or with Al Pacha on or around July 21st. In my two lawsuits, which were presided by this judge, she systematically made arbitrary rulings to prevent me from obtaining evidence. Of course, in that process, Judge Conkey contravened or violated Michigan law, the Michigan court rules, and the Michigan rules of evidence. On January 20th of 2016, Judge Conkey displayed her awareness that I was intending to conduct discovery on Down Foods, my father's former employer. At that hearing, Judge Conkey stated, "To the extent that you are already pursuing discovery, I won't stop you in that process, but I'll allow you to continue to pursue what you are working on right now." Then 2 weeks later, on February 3rd, there was another hearing, this time to compel Down Foods to comply with the subpoena which I had submitted months earlier. At that hearing, Judge Conkey surprisingly ruled in favor of Down Foods, thereby preventing me from obtaining any and all evidence from that company. When I reminded the judge about her words, which she had said barely 2 weeks earlier, Judge Conkey's response was, "No, this is a different matter." Of course not. What matter? What is wrong with her? There was no different matter. The reason why I always wanted to conduct discovery on Down Foods is to demonstrate that, generally speaking, an employer is reluctant to admit that it terminates or fires an employee as a result of Maria Vigor's actions. In particular, Maria Vigor's harassment and interference with people's employment. I don't understand, I don't know what different matter Judge Conkey had in her mind, but this shows how somebody to whom we are told to refer as honorable simply does not honor her worth. The reason which Judge Conkey gave for her erratic and obstructionist ruling on February 3rd is that the Down Foods records constitute prior act evidence and therefore it was inadmissible in my lawsuit. That shows that Judge Conkey is clueless about Michigan Rule of Evidence 404, which states that prior act evidence is inadmissible if it is used only on grounds of the perpetrator's propensity or inclination to commit a crime. But the same rule of evidence makes it clear that prior act evidence is admissible for other purposes, and it gives a non-exhaustive list of purposes for admissibility, such as method or intent or system in doing an act. In my lawsuit, I wanted the prior act evidence as a proof of the effect that Maria Vigor's acts have on third party or other entities. It was not to prove Maria Vigor's propensity or that Maria Vigor's propensity to perpetrate crimes demonstrated that she perpetrated the crime here. I had already proved that without need of resorting to her propensity. Another recent ruling or opinion released by the Court of Appeals of Georgia illustrates how pathetic and misinformed is Judge Conkey in regards to prior act evidence. The Court of Appeals of Georgia states that it is an abuse of discretion for a judge to preclude prior act evidence in cases where the defendant disputes or contests the mental state that he or she had at the time of committing the offense or the crime. That was the situation here because at that point in the lawsuit, Maria Vigors was arguing through her attorney that she made her defamatory statements as a result of her delusional state, and that she did not make the defamatory statements knowing them to be false, which in legal terms is known as actual malice. The records from the Downfoods would disprove Maria Vigor's allegation, because it would show that Maria Vigors does not need to be mentally ill to commit the offenses of defamation, harassment, stalking, interference, etc. Also, the police report where Maria Vigors falsely accused my father of domestic violence will constitute admissible prior act evidence, which shows that she falsely accuses others of crimes, even though she is not delusional and she is not in a psychiatric unit. A much older authority originating from the Michigan Court of Appeals acknowledges that a system which allows judges to break their promises with impunity is likely to be perceived by the public as inconsistent or even hypocritical. That applies to this lawsuit in regard to Judge Conkey, and I think that's an understatement. Judge Conkey's erratic behavior by promising me on January 20th that I will be allowed to conduct a discovery, and 2 weeks later breaking her promise or disavowing her own words is not only inconsistent and hypocritical, it is outright erratic and deliberately misleading. Because Judge Conkey stated during campaign that following the law is not the hard part of being a judge, the only conclusion available here is that Judge Carol Conkey is a charlatan. She keeps making adverse rulings so that later on she can decide the entire case in a manner that only fosters criminal or unlawful conduct. Interestingly, the emails involving Downfoods employees were provided by my father himself 2 years later when he violated or abused the law of personal protection orders. It is ironic because in that way he waived the protective relief that this immoral judge granted to him. I will develop that story about my father's violation of the law of personal protection order in a separate story, because that has nothing to do with the current matters and the two lawsuits I am covering in this series of videos.